Okay, hello and welcome everyone. Today what I'd like to do is to go through the Victorian Government's sex work decriminalisation discussion paper that they've made available on the Victorian Government website. So, as in my video yesterday where I talked about the Government of Victoria decriminalising sex work, which is a major win for the red light community here in Victoria, Australia. So I'm going to go through this paper and then I'm going to give you my thoughts. So it's a bit of an off-the-cuff presentation, and I've read through this a number of times last night and had a bit of a think about it. I'm going to be doing a little bit more thinking about it as well, and do more of an analysis of it later, perhaps bringing other people in. I might bring Steve into the discussion and a couple of other people who I know are interested in the industry. So, overview. In Victoria, sex work is currently regulated under a legalised model, which means that sex work is only legal if it takes place within the licensing and registration frameworks established by the Sex Work Act of 1994. The Victorian Government recognises that sex work is a legitimate form of work that should be regulated through standard business laws to safeguard workers and reduce stigma. The Victorian Government will decriminalise sex work in Victoria to maximise sex workers' safety, health and human rights, whilst also reducing stigma and fear of criminal repercussions for sex workers. The questions in this paper are intended to guide your feedback on the implementation of sex work decriminalisation in Victoria. Your insights will help to ensure the changes are on the right track and that the decriminalisation of sex work is applied in a way that reflects community attitudes and expectations. Background. In November 2019, the Victorian Government asked Fiona Patten MP to lead a review to make recommendations for decriminalising sex work in Victoria. The review consulted with sex workers, sex worker peer organisations, legal, health and education support service providers, commercial operators and industry organisations, and workplace safety agencies, local and federal government agencies, law enforcement agencies and other community and expert organisations. After considering the review, the Victorian Government has decided to decriminalise sex work in Victoria. The decriminalisation of sex work will remove offences and criminal penalties for consensual sex work. This will include decriminalising street-based sex work in most locations and repealing public health offences. Repeal the Sex Work Act of 1994 and regulate the sex work industry through existing regulatory agencies, and introduce supporting reforms in areas such as planning, public health and anti-discrimination. The current sex work regulatory framework. The current sex work regulatory framework in Victoria has several issues. Most significantly, the current framework perpetuates harm, stigmatisation and discrimination of sex workers who are simply undertaking their work. The current system has a complex, dangerous two-tiered industry. The current system is complex, costly and onerous. This has led to poor compliance and the growth of large, unlicensed sex work industry in Victoria, which neither criminalisation nor licensing has been able to eliminate. This system has many negative impacts for sex workers and business operators, including increased vulnerability for sex workers who are not registered or who work in unlicensed businesses, including poor access to safe sex equipment, justice and workplace health and safety oversight, significant costs and time burdens for sex workers and business operators to try to lawfully engage in the market and limit commercial incentives for compliance. Sex workers in non-compliant businesses are particularly vulnerable, facing stigma, mistreatment, and an inability to seek help without implicating themselves in illegal activity. Sex workers are at increased risk of experiencing violence. Sex workers report unsafe working conditions in both the licensed and unlicensed sectors. These workplace safety issues include increased risks of occupational violence, a lack of understanding of the organisational health and safety needs of the sex work industry, poor access to justice if a crime was committed at work, poor quality and security of working premises. These issues are exacerbated by the lack of autonomy, stigma and discrimination experienced by sex workers. This has a range of impacts on the health and safety of sex workers at work and in the community. Sex workers experience persistent discrimination and stigma in the community. Destigmatising the sex work industry and reducing discrimination is essential for protecting people working in the industry and shifting public perceptions of sex work. Entrenched negative perceptions of the sex work industry impacts sex workers' mental health, reinforces attitudes that drive violence against sex workers, creates barriers to accessing healthcare, social services and housing, and limits educational and employment opportunities for workers, including those who wish to leave the industry. Criminalisation limits the agency and independence of sex workers to make free and fair choices about their life and participation in a legal industry. The existing framework implies that sex work businesses and sex workers require a criminalisation approach from the government to reduce harm to the community. However, the result of this approach is not less harm for the community, but increased harm to sex workers. Criminalising sex work reduces sex workers' access to justice. Many sex workers are unwilling to report instances of violence, mistreatment, or suspected trafficking out of fear they may be prosecuted. The current criminalisation approach pushes the sex industry further underground, beyond the sight of regulators, support services, and the community. Criminalising street-based sex work impacts sex workers' safety and welfare. Street-based sex workers are more vulnerable due to a range of issues including homelessness, substance misuse, and/or pre-existing trauma. The criminalisation of street-based sex work undermines workers' safety and rights. It also inhibits their ability to access essential services and forces sex workers to operate in risky and dangerous ways to avoid prosecution. Restricting sex work businesses to certain areas creates safety risks for sex workers and have not been proven to work. Restricting sex work businesses to industrial zones makes sex workers more vulnerable to crime due to the lack of public transport, limited foot traffic, and poor lighting. Other models of decriminalisation cause harm to sex workers. Models of decriminalisation that criminalise clients but not workers can make sex work more dangerous. Research shows that sex workers who are financially dependent on clients are compelled to accept clients who refuse to give their legal names or insist on remote locations. This means sex workers are unable to practice harm reduction strategies for safety. What decriminalisation of sex work will look like? To decriminalise sex work, the Victorian Government will regulate the sex work industry, just like any other industry, by agencies such as local government, WorkSafe and the Department of Health. Remove offences and criminal penalties for consensual sex work, including street-based sex work in most locations. Repeal the sex work licensing system, the Sex Work Act of 1994 and associated regulations, and regulate the sex work industry through standard business laws. Repeal offences related to mandatory testing and sexual health and introduce a new public health and infection control framework for the sex work industry focused on health promotion and harm reduction. Strengthen anti-discrimination protections for sex workers under the Equal Opportunity Act of 2010. Amend planning controls under the Planning and Environment Act 1987 to support decriminalisation and reduce harm for sex workers. Remove outdated advertising controls and restrictions on sex work businesses holding liquor licenses. Offences and criminal penalties. The Victorian Government is decriminalising street-based sex work in most locations. Soliciting or loitering for the purposes of street-based sex work will still be illegal where it occurs near or within view of a place of worship, school, or other select locations frequented by children. Additionally, the Victorian Government will dismantle the sex work licensing and registration system established by the Sex Work Act of 1994. This means that there will be no criminal penalties associated with operating a sex work business without a license, or for working as an independent sex worker without being registered as an exempt owner-operator. Criminal offences related to children, coercion, and other forms of non-consensual commercial sexual activity will continue to apply. Specifically, offences under the Sex Work Act of 1994, which concern children and coercive commercial sexual activity, will be moved to the Crimes Act of 1958. The Victorian Government will continue to explore means of addressing sexual assault to reduce harm within the sex work industry, and awaits the delivery of the Victorian Law Reform Commission report into improving the responses of the justice systems to sexual offences. Public health. The stigma surrounding sex work and sexually transmitted diseases is a perception that is not supported in evidence. Evidence indicates that sex workers have comparatively higher rates of compliance with safer sex practices and low rates of sexually transmitted infections than the general population. In addition, existing criminal laws that make it an offence to recklessly cause or engage in conduct that may cause serious injury, including infecting someone with a sexually transmitted disease, already apply to the sex work industry. To address this stigma and treat the sex work industry in an equivalent manner to other industries, the Victorian Government is repealing public health offences from the Sex Work Act of 1994. This means sex workers will no longer be required to undergo mandatory sexual health testing, nor will there be criminal repercussions for failing to practice safer sex. To support decriminalisation, the Department of Health will be developing a new public health and infection control framework for the sex work industry, with a key focus on health and well-being. The proposed sex work reform will strengthen public health action for sex workers, including access to sexual health and wrap-around support services through community education and engagement. Anti-discrimination protections. To protect sex workers from discrimination, the Victorian Government is amending the Equal Opportunity Act of 2010 to include a new protected attribute of profession, trade, occupation or calling. Section 62 of the Equal Opportunity Act 2010, which currently provides that it is lawful for a person to refuse accommodation to another person on the basis that they intend to use it for lawful sexual activity on a commercial basis, will also be repealed. This will address stigmatising social attitudes relating to sex work and remove a barrier to sex work taking place in safe locations. To address economic and social barriers that arise from having a criminal record associated with sex work, people with historical sex work convictions may also be eligible to have their convictions spent under the Spent Convictions Scheme, introduced by the Spent Convictions Act of 2021. Advertising and liquor licensing. The Victorian Government is removing antiquated controls on advertising by sex work service providers under the Sex Work Act of 1994. The current advertising controls imposed on sex work businesses are discriminatory in nature, unfair in the application to the sex work industry, reinforce stigma against sex workers, and put sex workers at increased risk of harm. Sex work advertising will still be required to comply with all other laws and regulations governing advertising in Victoria and Australia more broadly. The Victorian Government will monitor sex work advertising following decriminalisation and retain the power to put in advertising controls through regulations if required. The decriminalisation of sex work will also allow brothels to apply for a liquor licence, subject to the standard liquor licensing framework established under the Liquor Control Reform Act of 1998. Planning controls. Planning controls for the sex work industry are currently established under the Planning and Environment Act of 1987 and Part 4 of the Sex Work Act of 1994. Upon repeal of the Sex Work Act, the Victorian Government will establish a new planning framework for the industry to support decriminalisation. This framework will have a clear focus on harm reduction for sex workers and implementation of controls which are proportionate and reasonable. Two categories of sex work businesses are proposed for consideration: commercial and home-based, to account for different amenity impacts of each type of land use. It has been decided that, subject to appropriate planning controls, commercial sex work businesses will be able to operate in commercial and residential zones. Sex workers will also be able to operate a home-based business. Establishing planning controls that are proportionate and reasonable, rather than unnecessarily restrictive, is more likely to result in sex work businesses complying with planning requirements, with corresponding benefits to councils, the local community, and health service providers. Separation distances. Proposed outcomes. Sex work businesses are treated the same as any other business and regulated through planning controls which apply to all businesses in Victoria. Current issues. Under the Sex Work Act of 1994, sex work businesses are prohibited from advertising within, prohibited from establishing within 200 metres of a place of worship, hospital, school, education and care services premises, children's services centre, or any other facility or place regularly frequented by children for recreational or cultural activities. So this doesn't apply within parts of the City of Melbourne, that's the CBD. These separation requirements are discriminatory, reinforce harmful social stigma towards sex workers, and are a barrier to sex work taking place in safe locations. Changes being considered. The Sex Work Act of 1994 will be repealed, and the use and development of land for sex work will be regulated under the Planning and Environment Act of 1987. The Victorian planning provisions will be amended to implement non-discriminatory planning controls which support decriminalisation and harm reduction for sex workers. It's proposed that there will be no separation distance requirements between sex work businesses and particular land uses, including dwellings. And then we've got some issues for consideration. So they're asking some questions here based on these changes being considered. So I'm not going to go through some of those issues for consideration. That's just a list of questions, and each of these sections have got them. Commercial sex work businesses. Proposed outcomes. Commercial sex work businesses are treated like most other businesses and are only subject to additional planning restrictions which are proportionate and reasonable. Sex work businesses are not to be discriminated against in planning permit applications. Current issues. The Sex Work Act of 1994 and current planning regulations prohibit the establishment of commercial sex work businesses in a range of land use zones. In practice, this means commercial sex work businesses have been largely pushed to industrial areas. There are obvious safety concerns for workers in limiting the operation of large commercial sex work businesses to industrial areas. Lack of public transport, limited foot traffic, and poor lighting makes a sex worker's commute to and from work more dangerous than if they were able to work in other areas. Changes being considered. The Victorian planning provision will be amended to allow commercial sex work businesses to operate in commercial and residential zones, subject to appropriate requirements. Home-based businesses. Home-based sex work businesses are treated the same as any other home-based business and regulated through planning controls which apply to all home-based businesses in Victoria. Sex workers are not permitted to operate from their own home at the moment without a permit, unlike most other home-based businesses. Sole operators and small-scale sex work businesses face onerous planning and zoning restrictions akin to those for large commercial brothels, which prohibit them from operating in residential zones. Changes being considered. Repeal the Sex Work Act of 1994 and amend the Victorian planning provisions to allow sex workers to operate home-based businesses under the same planning controls as any other home-based business. This will mean that, subject to meeting certain amenity impact thresholds, for example, number of workers or floor areas of the dwelling, a sex worker operating a home-based business would not need a planning permit. Signage. Signage and advertising for sex work businesses are subject to the same planning controls applicable to other businesses. The Sex Work Act of 1994 and Sex Work Regulations of 2016 govern advertising for sex work businesses. Upon repeal of the Act and its associated regulations, government will ensure controls about the content and placement of signage for sex work businesses are appropriate. Inappropriate advertising signage has the potential to impact public amenity and the character and image of local government areas. There is also the risk of inadvertently exposing children to sex work via signage and other promotion. Changes being considered. Regulation of sex work business advertising will be aligned with regulation for similar industries such as live sexually explicit entertainment. Existing planning controls which apply to signs of businesses operating a home-based business or operating in certain zones will apply equally to sex work businesses. For example, restrictions on size, location and lighting. These requirements do not relate to content. Local government will continue to be able to make and enforce their own laws regarding general community amenity. So, what do I think of this? Well, I've got one word: wow. Wow. The Victorian government here has really listened to sex workers, to umbrella organisations, which includes my own non-profit organisation, who made a submission to the Sex Work Review. They have really got this right. They really have got this right. Finally, I can say the government has listened and they've got something right. Now, this isn't yet in law, right? But where the government's going with this, by the end of the year, once this bill is tabled in Parliament, they've really got this right. They really have. So within the next, over the next 2 years, things are going to change substantially here in Victoria for the better. For the better. I mean, there is so much in this document that I really love, that they've just got it right. Now, my understanding is Fiona Patten, the leader of the Reason Party, who conducted the review, was flooded with submissions from all sorts of people within the community, from sex workers, umbrella organisations, commercial operators, and this document here, what you see, is the result of all those submissions, all the advice that the government received from people within the industry. They've come back with this document. It's just wow. I mean, the news yesterday, this was all over the news. So article after article, and it made the television news as well, that Victoria is doing this. So I'm just going to go back through some of these sections and just give some of my comments based on my past history, things that I've tried in the past, and other ideas and thoughts. So this one here, commercial sex work businesses. This is amazing. I mean, at the moment, like, you might remember that I was looking to create a brothel, a ladyboy brothel here in Melbourne, Victoria, and I was looking in industrial areas, and I had problems dealing with councils because every place that I looked for in an industrial area that was away from everyone else, that was isolated, that it was the perfect location under the existing Sex Work Act of 1994, the councils still said no to, and still caused me nothing but problems. So under this new legislation, it'll mean that a brothel can operate within a normal commercial a commercial area. So like just a shopping strip, or here in Victoria we have within the inner and middle suburbs we have I guess strip-based shopping, which is like an old commercial shopping area that's been sort of refurbished, and instead of those big malls that tend to proliferate in America. I mean, sure, we have some of those as well, but most of the suburbs have got these small commercial shopping districts, and it would mean that a brothel would be able to operate within those areas, which is fantastic. This is common sense. This is great. It means we won't have to go to an industrial area away from everyone and everything. So yeah, this is fantastic, and the government recognises that those industrial areas, there are safety concerns for workers, because I mean, like that area in Corley Road in Yarraville that I was looking at, that is out of the way. There is nobody around, especially at night. When it comes to security, like if anything went on out there, even though that it's within the middle suburbs, but there's nobody around, right? It's so isolated within that particular area, and it is dangerous. You know, one of the 48 laws of power is isolation is dangerous. Do not build fortresses to protect yourself, right? So this is really good. I really like this particular section. These changes to allow commercial sex work businesses to operate in commercial and residential zones. So that's interesting as well. And residential zones. So within a residentially zoned area, sex workers and commercial sex work businesses can operate. So for example, you know, where I live, the family home is on a large block of land. It's over 1,000 square meters within the it's almost an inner suburb now because of how Melbourne is developed. So within my own house, I could now convert it into a brothel if I wanted to. Now, funnily enough, the house that I live in actually used to be a brothel prior to 1994. The people that my parents purchased the house off were actually running a sex work business here before the laws changed. So, you know, this is really interesting that people can operate a commercial sex work business out of their house based on these changes. So I really like this section about commercial sex work businesses and the changes that they're considering here. That's just amazing. Home-based businesses. So these changes being considered, to repeal the Sex Work Act, amend the planning provisions, allow sex workers to operate home-based businesses under the same planning controls as any other home-based business. So this is amazing as well, because you can't currently do this under the Sex Work Act, right? So they'll allow sex workers to operate from home. Just fantastic. And at the moment, these onerous planning and zoning restrictions apply to small sex workers, which are just a complete nightmare to navigate. I mean, everybody knows on my channel that I registered myself as a sex worker so that I could go through, partly to protect myself based on the existing laws, and I wanted to bring my lady boyfriend over from Thailand, and partly to see can I comply with the law. I'm now a semi-retired public servant, and I could not comply with the law the way that it was. It was so complex, so onerous, that it was impossible to comply with the law. An absolute crazy situation. So this is common sense, these changes that are being considered, right? I think this is really good. So yeah, I love this part about commercial sex work businesses and being able to operate from normal commercial areas. I love the fact that you'd be able to operate from home, the sex workers would be able to operate from home. This would mean that if I was to bring my friend over from Thailand, my ladyboy friend, there's possibilities that she could work from home. Of course, I'd need to get a proper visa for it. I believe that so she should be on a working holiday visa, essentially. They're still not mentioning anything about specific visas for sex workers within this. My understanding is that's out of scope. I contacted Fiona Patton about this. That particular part, visas, is out of scope for the review. But still, this gives me a lot more flexibility when it comes to bringing my friend from Thailand here. And a number of you who are listening to this presentation, you're also in situations where you want to bring your friends over from Thailand or the Philippines, and some of those friends may be part-time sex workers, and they may want to work. So within this legislation, or where the puck is going here, you'd simply get a visa for the person, a working holiday visa, bring them over, and they would be able to work legally and would be able to operate from home here in Victoria. Just fantastic changes here. These planning controls are amazing as well, just to know that we wouldn't have to operate from industrial areas. So there's a lot to like in this. Now, the advertising and liquor licensing, this is just wow. This blew me away, because I thought, this blew me away because I thought, wow, this particular section here, right? If brothels, the decriminalization of sex work will allow brothels to apply for a liquor license. So that opens up the possibility of creating Thai and Filipino style bars here in Melbourne. Now, of course, they wouldn't be open air bars. They would have to be inside, because the weather in Melbourne is cold most of the year. But it opens up that possibility, right? It opens up the possibility that I could go and create a brothel. I might even do a community-owned brothel. Some of you know that I work part-time. I do volunteer work within the community, and there is a particular bar here in Melbourne that's community-owned that I own shares in. That particular model, potentially I can see an opportunity here to create a community-owned brothel, right? So being able to combine sex and alcohol under the same roof, that was previously illegal. But where the puck's going here with what the Victorian Government's saying is that brothels will be able to apply for a liquor license. So this makes it fair based on, and some of you may know, when some years ago my business partner and we tried to create a ladyboy night at Platform 1 nightclub in Banana Alley in the city. And we ran into problems with legislation. And next door to the tunnels there, one of the tunnels was a sauna, a gay sex on premises operation. And I'd never been to a place like that before. And I met the CEO of that place, and he took me through. And I said to him, look, I'm a bit confused here. You're telling me that homosexuals can walk in here, you serve them alcohol, you sell them alcohol, and they can have sex with one another, and that's 100% legal. It's like, yeah, so long as money doesn't change hands. I said, wow. Under the Sex Work Act of 1994, it's illegal to combine sex and alcohol for heterosexual people in a commercial business, in a brothel. So this part here will put it's all on an equal footing. It won't just be the gay and bisexual man that can walk into a gay sauna, drink alcohol and have a great time with one another, but anyone will be able to walk into a brothel, heterosexual men will be able to walk into a brothel and have a drink with the working girls, have a good time, and that will be legal as well. So that's just wow. That is huge. That's gone further than what I thought the government would go. So I'm just I'm blown away by this. I just think, wow, this is fantastic. I mean, over in Thailand, this is the sort of stuff that that people enjoy. They can go to a bar, they can have a drink with the sex workers there. They go upstairs, have sex, have a good time. Now, prostitution is technically illegal in Thailand, but that particular model of being able to combine alcohol with sex, it works. Sex and alcohol go together brilliantly. There's only one other thing that goes together as brilliantly with sex and alcohol, and that's night swimming. Combine night swimming with sex and alcohol, and you've got it made, right? Particularly in Thailand, right? So this is just fantastic. This really opens up a lot of possibilities. There is a lot to like about this. A lot to like about this. Now, what I'll be doing, I'll be clubbing together with my business partner and other people that I know, and we're currently going through this together. And we're looking for commercial opportunities in this. So we might actually put some money into a hat and go and start something, right? Go and start a commercial business, because, I know years ago I put up a video why I'm not starting a ladyboy brothel in Melbourne, right? And there was the thumbnail was a guy in a suit with a whole lot of red tape surrounding him. This legislation, where the puck is going, removes all that bullshit, right? It removes all that bullshit, and it opens up possibilities that that just weren't possible before. So, as a scientist or a former scientist, right? When the facts change, I have to change my opinions. I have to change my thoughts on it, and where this is going, I really like. So, if you're listening to this and you're interested in clubbing together with with me, forming a group of investors, doesn't mean that you will have to run the place or do any kind of management of the place or anything like that. But get in touch with me if you're interested, if you're in the market as a potential investor. I'll put you in contact with people that I know that are potentially interested in investing as well. It might be that we start a place and we have other people manage it. We just become silent investors, or we start a model similar to Pride Bar in Footscray. I mean, imagine that. Imagine a community-owned brothel owned by the workers and the clients. So you walk in, you can drink alcohol and have a great time with the workers. You pay for the service, and at the end of the year, you get a dividend back, right? Because you own the place, you own shares in the place. So could you beat that? I don't think that could be beaten. I don't think it would be possible to beat a situation where you've got a community-owned brothel where you can drink alcohol with the workers, have a great time, walk in, pay your money, and then get a dividend back at the end of the year, right? That's amazing. That's the sort of thing that I'm thinking of based on my involvement in that community bar in Footscray, which I'm a part owner of. So, yeah, look, what do you all think? Please comment on this video. Get in touch with me. You can reach me very easily. Just make some comments on the video below. If you'd like me to get in touch with you, I can do that. So yeah, my email address is thepretender@mail.uncensorable.purpleparadise.com.au, and I'll put my email address in the description of this video, how you can contact me, and yeah, let me know what you all think. I'm just blown away by this. I just think this is fantastic. This is a real wow. This is a huge win for the sex industry here in Victoria, with many commercial possibilities coming up, right? Many commercial possibilities coming up. Yeah, much better than what I thought this would be. This has gone further than what I thought that the Victorian government would. All right, all the best, everyone. I'm the Pretender.